Hello everyone, and welcome to another episode of grooveu's The Woodshed series. I'm Dwight Heckelman. I'm the director here at grooveu, but I'm here today because I'm also an instructor, and I have a pretty extensive music business background. Coincidentally enough, this week's topic is music business. And one of the questions I frequently get asked in the modern music environment, one of the first questions my students kind of have is around copyright, beats, sampling, mashups. How does that all work? What do I need to do? With that in mind, I'm going to cover some of those ins and outs today with a really broad brush. Specifically, I'm going to introduce a few things, but tell you I can't really get into that. So here's just some real basic knowledge that you need to know. And I'm going to assume that you don't have much or any knowledge of copyright and licensing as it pertains to music, for the purposes of today's discussion at least. So that in mind, let's kind of jump right in. Let's break down the word copyright and what it is and what it does. So any discussion we're going to have about sampling and beats and mashups and copyright, we're going to have to define what we're talking about first. Also, I need to sort of preface this by saying I am not an entertainment attorney. My background is in music publishing and engineering and some record label stuff, but I don't have my law degree, so do not take anything I'm going to tell you today as qualified legal advice. Always, always, always consult a qualified entertainment attorney in the event that you need to really find out the ins and outs and nuances of some of the things I'm going to talk about. But anyway, let's talk about copyright. Copyright is the reason we're allowed to make music. The law, specifically we're talking about the Copyright Act of 1976. That law grants the creator the exclusive right to copy. The copyright, the exclusive right to copy. Okay, so think about that. If you make something, you and only you own the legal rights to make copies of it. Also, the law is going to afford some other more nuanced things like you and only you have the right to make derivative works of it. That's specifically going to come into play when we talk about sampling, right? But for now, you, the creator, if you are going to be the one we're talking about today, you have the exclusive right to copy. Under this law, there's two big things the copyright law seeks to do. One is it protects you, right? So if somebody else tries to take your right to copy and make copies without your permission, the law says, no. There's legal responses to that. The other thing that it does is it provides a very loose framework as a way for you to get paid for what you're making. So it's defining what you're doing as property, intellectual property in particular. And it's saying you get two things with this property. You're going to be protected because it's yours, and you're going to get paid for it. If we frame everything inside of those two contexts, are we talking about protection or are we talking about payment? Maybe some of the rest of this discussion makes some sense. So let's take that first part. Number one, provides protection for you. The copyright law protects you for things that you make. Well, what do we mean, things that I make? What's actually covered? It's almost easier to explain what's not covered by U.S. copyright law. One is ideas are not covered. Only individual expressions of ideas. If you think about it, you already know this, you see this. If I have an idea for a song, I got this idea for a song and it's about a guy and a girl and they fall in love. That's my idea, so I'm going to copyright it. Yeah, you can see that's not going to work. That's 98% of the songs that are out there, right? But if you have a very specific idea, and what we're going to call the individual expression of that idea, then that is protected. So if you write, a song about a guy and a girl being in love, and you call it All Because Two People fell in love and your name is Brad Paisley, then yeah, that's his individual expression of an idea, right? Titles in general are also not subject to protection. Again, you probably know this. You've looked for song titles, probably through YouTube, to play a song, and you'll see 5, 6, 20, 30, 40 songs with that title, and they're all different songs because they're all individual expressions of an idea. So you can't protect titles in general. There's some yeah buts, but I'm not going to get into that right now. Lastly, and this is just something that you maybe never thought of before, the Copyright Act of '76 also does not protect the physical media on which the copyrighted work is contained. You probably know this if you've ever sold a CD to buybacks or a CD place, right? You take a used CD in there, they pay you money for it. You don't have to turn around and pay the record label and the writers on that again, right? The protection only extends to the first sale, right? To the very first time that was sold. They get paid the first time it's sold. After that, they don't get paid again on resales. Okay, so that's the idea with resale. Not really important in our discussion, I just find it interesting. Here's what the Copyright Act does protect, though, and this is you can tell this is something that was written by lawmakers and lawyers, right? Because I'm going to read it to you sort of as we understand our legal definition of copyright to be, and you're going to probably be like, what? All right, we'll straighten it out. So the Copyright Act protects any original work. Let's stop right there. Any original work. What makes an original work? Wow. That is a really loaded can of worms, right? That I'm not going to try and open, and smarter people than me have tried to unpack this. I think we already talked about it earlier this week, but if you haven't seen the web series Everything is a Remix, kind of blows your mind about what's original and what's not. Let's just say we can define an original work, that it's something that I thought of on my own and am therefore going to create. So any original work that is, and this is where we get into this legalese, fixed in a tangible media of expression from which the work can be reproduced. All right, that sounds complicated, but it's really not. I get copyright protection if, number one, it's an original work, and two, I somehow find a way to make this work, in case of music, listenable or duplicable, right? That somebody else could see it or hear it and recreate my work. That's that fixed in a tangible media of expression from which the work could be reproduced. All right, so if I have a song idea and it's a fully developed song and it's in my head, but I never record it, it's not subject to copyright protection. If I have a song idea and I only perform the song live for people and it never gets recorded, again, nobody can take that tangible media, in other words, the recording, and reproduce my work. But if I have a song idea and I sit down with my computer, my laptop, and I plug in a microphone and I sit here with my guitar and I play that song, boom, I now have copyright protection. It's an original idea and it's been fixed in a tangible media of expression. I could also, if I was really musically sort of gifted, I could have the song idea and I could just transcribe the song into sheet music. Again, if I give that sheet music, the words and music to somebody, they're going to go, oh yeah, I see. I can read that music and I can reproduce it. Okay. So, what's not protected? Ideas, titles, pieces of plastic for the most part. What is protected? An original idea that can be reproduced from something I've created. At that moment in time, the moment I've done that, the moment I've sat down and recorded this song, I am subject to US copyright protection. Everything I tell you about copyright has a big yeah but associated with it. Even though I'm subject to protection, at that moment, it's kind of a toothless protection. I have to do other things if I really want to be protected, if I really want my work to be protected. What is protected? Once I've done this, what specific rights are protected inside of my original work that I've fixed in a tangible media of expression? When it comes to music, we generally talk about two things, and most people miss this, so this is kind of important, and I hope you don't. the first part of what is protected is the song. And by the song, I mean the words and music, the lyrics and notes, right? That is subject to copyright protection. And if you look on the back of a CD, if you still have a CD, and you hold it up, you will see circle C. That's symbolizing that that is a protected work. You'll see the year, typically, the work was originally created. And then you'll see a name. And the name generally will be the songwriter or the music publisher, right? It won't say the record label. We'll talk about that in a minute. Because the songwriter owns the words and music. But there's another part of this song that you fixed in a tangible medium of expression, if you've recorded it at your computer, that is subject to copyright protection. And that's the actual recording. The actual, let's call it the unique auditory interpretation of your words and music. You know, if you had a recording and you made your song sound like a country song, that's unique. Then that same words and music played as a rock song or rapped into a hip hop song, right? So there's a unique interpretation in the instrumentation and the style, right, that's done. So that is also subject to copyright protection. Not only are your words and music protected, but your unique auditory interpretation of that song is protected. The really big long technical name for that, what we've created, is called the phonographic master recording right. Nobody hardly ever says that. They're going to call it the master right, or the master recording right, or sometimes the phono right. You have copyright and phono right, like phonograph. And that, if you look on the back of a CD, will be represented by a circle with a P in the middle of it. P for phonograph, P for master phonographic right. And it won't say copyright your favorite artist in the year. It will say circle P, Sony Records, for example, right? Because the record label in general owns the recording, and the writer, oftentimes the artist is the writer, owns the words and music. Now you can see that although these rights are different, when it comes to one of them, I can't have it without the other one. I can't have the circle P, the recording, unless I have music, right? So if I'm using a circle P, if I'm using someone's recording, I'm going to have to pay someone for the words and music as well. The inverse isn't true. I can be using someone's words and music and be making my own recording, and then I'm not paying for that circle P right. That's a really important idea, so let me express it one more time. The phono right has to be coupled and used with the copyright. There's kind of no other way to do it. The copyright, the circle C, isn't always coupled with the phono right because I might be making my own recording. Okay, how is this protected? So we're still on number one. It provides protection. How is protection provided? Okay, I'm not going to get into it because it would be a whole other lesson, but you have to, if you want to gain the maximum protection under the law, you have to register your copyright. Now remember, we said the minute you fix it in a tangible media of expression, it's subject to law, so why do I have to register it? Well, registration is a formality with a lot of benefits. Things like filing a lawsuit, things like the strongest evidence in a court case, things like being able to get damages and recover attorney's fees. I don't want to get into all those. If you create original words and music, you should file and register your copyright with the U.S. Copyright Office. It's the only official way to do it. If you want to sort of figure this out on your own, it's really not that difficult. But you can go to copyright.gov, G-O-V, and they have little tutorials and things that explain how you register a work. Cost you a little bit of money. You have to upload. You have to fill out an online form. You have to create an account. But believe me, it's totally worth it if you're serious about music. I'm not going to get into how that happens today. A little more than time that I got, and probably more attention than you or I have to cover this in the same lesson.
This life is for the audio engineer who skips a party on a Friday night just to mix a song until the sun comes up the next day. People may call you crazy for wanting this life, but we call you our student. Is this your life?
Let's get into that second idea. So remember, copyright is going to do two things. It's going to provide me some legal protection, and it's going to provide a method or a framework that I get paid as the creator. That side of the business, the words and music side, getting paid for my words and music, is called music publishing. Now, if you're new to the music business, that term seems a little bit antiquated and kind of weird. If you think, a lot of people think about music publishing in the same way they think about a book publishing. Oh, well, a music publisher is probably the person who makes sheet music. Not really. That's a part of what a music publisher kind of does, and that is where it originally comes from. But it is not what the real business of music publishing is. Music publishing is the business of licensing the words and music. And when we say that, what happens is a songwriter, you might be the artist, might be the songwriter. The artist might not actually have written the song, but we'll say a songwriter wants to write songs. And they want to make money off these songs because the law is going to let them do that. But all they really want to do is write songs. That's what they're good at. They're going to use a music publisher. They're going to share the ownership of the words and music. And the music publisher is going to license the songs so that the songs can make money. How do songs make money? Well, lots of ways. Going onto a record is one way that's obvious, that the record label has to pay when the song goes on the record. It has to pay the songwriter. But yeah, I mean, today we're talking about, not only the physical recordings, but we're talking about downloads, we're talking about streaming, we're talking about YouTube, right? We're talking about songs placed in commercials, songs placed in movies. Man, there's a whole myriad of, songs that get played on the radio still, songs that get performed live. Yeah, anytime you hear a song, the songwriter's getting paid through the music publisher. And we hear songs everywhere, and we're hearing them more and more places than ever. So that's music publishing, and it pays the songwriter for the words and music. I'm not going to get into how all that works. There's a whole class we teach here on that, and that's a pretty complicated, involved legalese idea as it relates to what publishing is and how it works and how songwriters get paid and how the money flows. But we all can acknowledge they need paid, right? And the publisher is the one that does that on the words and music. Now, remember back just a minute ago when we were talking about that's half of a recorded piece of song? Well, the other half, of course, is the part that belongs to the record label, the recording. Now, record labels historically haven't generated a lot of income off of their master's ownership beyond the artist that it was originally recorded with. But they got really tuned into this in the early 1980s and all through the 1980s with the rise of rap and hip hop. Because hip hop and rap in particular are doing a process called sampling, right? At least early on they were, not so much anymore. We'll talk about why not so much anymore. Okay, so let's think about this idea of sampling, and let's use a song that maybe we're kind of all familiar with. Let's use Ice Ice Baby by Vanilla Ice, right? Okay, so Ice Ice Baby starts out, and it starts out with a riff that you're probably already familiar with because you probably know it from Queen and Under Pressure, right? Riff starts out dun 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 dun, right? So Ice Ice Baby starts out, that's how Queen's Under Pressure starts out. And most people, song comes on the radio and you don't know what it is until you hear the first lyrics. And then you're like, oh, that's Vanilla Ice, or oh, that's Queen. Okay, so what's happening in that moment, that first 8 bars of that song, and then that riff continues through Ice Ice Baby too, but in that first 8 bars in particular, or 4 bars in particular, as we hear that song. Okay, so Vanilla Ice is using someone else's words and music, right? He's using Freddie Mercury's words and music for Under Pressure. Not the words, doesn't matter, we don't split them up. He's using the music, he's using that riff that was created by Freddie Mercury. Dun, 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 dun. Okay, so that means that Vanilla Ice should pay Freddie Mercury because Freddie Mercury is protected, right? Makes sense. We just went through all that. Okay, so dun 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 happens. Vanilla Ice has to pay Freddie Mercury, a Queen, for the use of those words and music. Does he have to pay for the actual sound dun 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 dun? Well, that depends. If he took a Queen record and sampled that recording, then yes, he has to pay the record label for using that actual recording. Remember, they own that. Okay. Now, he could get around this if he were to take that riff, that dun 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 dun, and re-record it himself. He owns that recording now. Even if it sounds exactly the same, doesn't matter. He created a recording from existing words and music, and he pays Freddie Mercury. He doesn't have to pay Freddie Mercury's record label. And that's oftentimes what happens in these cases. Because what we call clearing, which is the process of getting a license from a record label, that's pretty difficult in particular. They're pretty protective of that. They don't like their stuff being used in that way. Historically, I mean, some of that's changing now, but it's pretty tricky. So he has to get two licenses: a license from the music publisher on behalf of Freddie Mercury for use of the words and music, and a license from the record label to use the sample. Unless he just takes Freddie Mercury's music and re-records it, then it's no longer a sample. It's for this reason that a lot of the early hip-hop stuff is pretty much impossible to do these days, right? You know, if you think about Beastie Boys, those tracks are stacked with samples. And this was all before this kind of understanding of what sampling was and what the rights encompassing it would be. And today, you could never recreate a Beastie Boys. You could not be a new Beastie Boys and create a track that used so many samples. There'd be so many clearances you had to get and so much permission. It would be really expensive, and you just couldn't do it. All right, so that's sampling and who needs paid under what conditions and how you can kind of avoid those. You know, if you recreate a new sample, you're in the clear. You don't have to pay that Circle P portion. If you don't, though, you can actually be in big legal trouble for doing that. All right, what about a mashup? So think about a mashup. If I were to take Taylor Swift's Look What You Made Me Do and mash it up with Right Said Fred, I'm Too Sexy. Yeah. Listen to them, they're pretty similar. It's actually been done. Who would I have to pay? Probably figured out the answer, right? I'd have to pay Taylor Swift as the writer, or her publisher, you know, who's representing her writer interest. I'd have to pay her label because I'm using that recording. I'd have to pay Right Said Fred as the writer, his music publisher, as representing him. I have to pay his label. So there would be 4 different licenses I would have to get to make a mashup. And then it would depend on how I'm using this mashup. Am I putting it on YouTube? Am I recording it? That's how they figure out what type of license to give me. So that's tricky, right? But here's a yeah but. Mashups in general are falling under something that we call a parody. And a parody has an exclusion in copyright law carved out for it that says if you're doing a parody, you don't have to compensate the copyright owners. Okay, there is a pretty clear line in the sand as it relates to this though. If you are creating a mashup and you have it and you create it for your friends and you throw it up on YouTube and you're not getting any revenue off of it, it's protected. It still might get taken down. I'm just going to be straight with you, and you would have to argue for it. But at least you're probably not, in general, legally responsible for any sort of breaking of copyright because that was a parody. But if you create a mashup with the purpose of selling the mashup as a new recording, or say generating ad revenue off of YouTube on your channel, you would have to get those clearances, and they would be pretty hard to get. So good luck, right? Just know that generating income tends to be the point at which a parody stops becoming a parody and starts becoming a commercial enterprise. And you got to be aware of that. You're probably in the product of your head right now. You're probably going, well, what about Weird Al? Yeah, it's a good case in point. I'm not going to get into that right now, but he actually does his clearances in a different way. Okay, let's talk about beats. It's kind of the one that is pretty contemporary and something that people do. When it comes to beats, there's kind of three ways that you can make a beat and make money on it. Most people are going to do it the first way, which is the way that will ultimately not get you paid the most. Most people that make beats that I know, they make a beat and an artist says, I want to buy your beat. When that transaction occurs, okay, here's 50 bucks, here's 100 bucks, here's the beat, go do your thing. What has just happened, if you are the person creating the beats, you are a songwriter. And by taking this flat fee for it and saying you can use it forever for however you want, you have just done pretty much what the law calls a work for hire. In a work for hire agreement, you don't own that Circle C anymore. You gave that Circle C, you gave your words and music and your ownership in your words and music to someone else. So if Jay-Z says, hey, I want you to make beats for me, here's 100 bucks, 200 bucks, maybe it's Jay-Z, maybe it's $1,000, and you do it, you're going to sign a work for hire agreement. Jay-Z is going to own that song and make all the millions and millions of dollars off of the records. So maybe that's not the best way to do it. Let's go back to you and Jay-Z again. Jay-Z says, hey, I want you to make some beats for me. You could co-write with him, right? You could say, all right, I'll take half the ownership and you'll take half the ownership, and then we'll share that Circle C. And, you know, maybe if it's the beat that ends up going on the record, you're also going to share that Circle P, right? So you're going to own part of the master. That's definitely a better way to do it. Because in that situation, what's happening is you're going to continue to get paid, and you wouldn't take money up front, or you take very little money up front, and you take that instead. All right, so you're the songwriter, you're also partial record label in that scenario I just outlined, and then you have some longer term income. It's not a work for hire. The third way you could do it is you could own all of the words and music, and you could allow Jay-Z to make a new phono recording, right? You could say it's my beat if you want to duplicate it on your own, or you want to license my phono recording, my master recording, that's fine. And not only could you license it in that case to Jay-Z, you could turn around and license it to anyone else because you own it. And he's going to use it in his song in a different way than someone else is going to. That's clearly the smartest way to do it, but it's probably not the way that most producers and artists are going to go for. But know those three paths that you could take, and you could potentially lobby for one versus another. Again, I'm going to say this as I close this out again. If you are ever in the position that Jay-Z approaches you and says, I want to use your beat, the first thing you should do would be to call a qualified entertainment attorney to help you work through how you're going to do this. And I guarantee that attorney will say, don't do it as a work for hire unless there is a lot of money up front. Otherwise, you're giving up your rights in it. Okay, hope that helped clarify beats, samples, mashups, some basics of copyright for you. Please, like our channels, subscribe, follow us on social media. We're on Instagram, Twitter, Facebook, YouTube. Make sure you sort of tune into these. This coming Monday, I'll be available to field some questions for you guys on some specific things you might have about copyright and beats and sampling. So, thanks so much for tuning in. Hope you have a great day.